hesitating a second while I organize my screens here. We're going to spend a little time talking about land surveys as they're presented and utilized by the engineering community. If there's an attorney or a client online, it applies. Most of everything I have to say will apply to you also. When someone looks at a survey, it generally is taken as a contextual document that has often very little restrictions on its use. Often you find yourself in a situation where you look at it, say, great, now I have what I need to complete my transaction, to begin my design, to evaluate circumstances on this property. Unfortunately, that's probably not the case. Every survey report has a purpose and has a set of limitations that goes along with that purpose. Let me start with a little background. I can't resist the temptation to quote Socrates, where he says that a man should know enough mathematics that he can determine if he's being taken advantage of when he buys a piece of land, or determine the diameter of the earth. I'm not sure how many of us can do the last part without considerable thought. By the time we get to the end of this conversation, you may wonder if you can do the first part. But in any case, that comes from quite a ways back in time. Socrates actually lived less than 50 years after Pythagoras. You'll remember Pythagoras and Pythagoras' theorem and several other philosophical issues. Almost 2,000 years later, we see mathematics developing and describing the world more precisely. Jerry A.K.A. published a system of maps or mapping, now referred as the A.K.A. cylindrical projection, and a significant amount of time after that, John Lambert produced a system of projections that included both conical projections and Mercator, and conical projections. Both the Mercator's and the Lambert's conical projections are used in state plane coordinate systems across the nation. In Texas, the projection that is used for the state plane coordinate system is the Lambert conical projection. This has an impact on all surveying work in Texas. Moving forward in time, we find that the 17th century is a very active time that basically generates modern land surveying. In 1620, Edmund Gunner introduced what we know as a gunner chain. Gunner chain is a chain linkage, got small links and longer links. The unique thing about this particular device, it is a very specifically a land surveying tool as contracted against a engineering tool. You would expect engineering measurements to be made in units of 100 feet. The gunner chain is 66 feet long. That looks a little obscure But when you do the arithmetic, i.e. multiply 66 times 66, you get 4356. That's the area of 1/10 of an acre. So the Gunther's chain is very specifically a land surveying tool. It's designed for laying out parcels of the land 1/10 of an acre in size, or you lay out 10 of them by 10 of them, you get a full acre. Also during the 17th century, the English Parliament passed the Statute of Frauds. The Statute of Frauds has been described as an attorney's retirement statute. Surveyors look at it as surveyor's retirement statute. Among other things, the statute of fraud was intended to minimize fraudulent conveyance of land, or at least claims of fraudulent conveyance of land, by requiring that all conveyances be in writing. And that writing must contain a description of the property to be conveyed. That piece of English law, common law, has been incorporated into the laws of every state of the United States of America. And it shows up in various forms and formats. In Texas, there are some 4 or 5 different versions of it. One dealing with real estate, another dealing with the practical requirements, others dealing with other financial issues. One little sidelight that may be interesting to the engineering community or any other business person involved. Statute of frauds in Texas, in one of its forms or another, also requires that for a contract of any kind to be enforceable, if it's more than $10,000, it must be in writing and signed by the person responsible for making the payment. But our subject is real estate conveyance of real property, and that's where modern land surveying originated in 1677, with the need to have descriptions of real property in the conveyance. Following right behind that, a gentleman named John Long, who was the surveyor of the king, published a book called Geodasia. Geodasia is a fairly complete textbook on land surveying. It goes so far as to describe the mathematics, the tools involved, how to make ink, how to make paper, how to make various colors of ink. It is fairly well received. It would probably have been better received in the Americas if it hadn't had a outright insult to the surveyors in the colonies in its preference. Find yourself a copy and read it. It's enjoyable. It's interesting to note that surveyors and engineers use basically the same tools, use overlapping terminology. Kind of obvious. The big difference between surveyors and engineers is the purpose of their work. Engineers spend their time trying to describe what should be, what needs to be built, what the results of contractors' efforts are going to be. Surveyors, on the other hand, are describing what is. Hopefully there's somebody. Often you wonder if there's definitions for what a surveyor is doing when it comes to land surveying and boundary surveying. The duty of the surveyor, it's been stated that the duty of the surveyor of public lands is to run around the land located and to see that such objects are designated as will clearly identify the locality and to call for these objects, natural and artificial, in his field notes of the survey. I know that all sounds kind of arcane. Well, it is. It's rather old. That statement was written by Justice Smith, Texas Supreme Court in 1867. This particular lawsuit dealt with a pair of surveys, and it had been in the courts for more than 10 years. You'll notice it was being ruled on shortly after conclusion of the Civil War. It's kind of interesting also that Justice Smith was an elected member of the Texas Supreme Court. That entire court was dismissed by General Sheridan, who was the appointed officer for Reconstruction in Texas. He appointed a substitute Supreme Court because the elected one was behaving retrospectively. The follow-up thought on that same thing was, although Justice Smith was a Supreme Court member for only a year, this particular court case, which we'll refer to further, has not been overturned. None of its features have been overturned, and it's referred to in the courts almost daily now, and it is particularly enjoyed by surveyors because it's got some complementary language in it. Another Supreme Court justice, this one is the Chief Justice in Michigan, same vintage of time, had this to say, and excuse me if I read it, you're not going to have time to read it yourself, and it's way too dense, and it's spoken in the words or the vernacular of the day. When a man has had training in one of the exact sciences, where every problem within its purview is supposed to be susceptible of an accurate solution, he is likely to be not a little impatient when he's told that under some circumstances he must recognize inaccuracy and govern his action by facts which lead him away from the results which theoretically he ought to reach. Observations warn us in saying that this remark may frequently be made of surveyors. Justice Cooley goes on after a very lengthy list of things that a surveyor ought to do and needs to do, including run around the property. Concludes with surveyors are not and cannot be judicial officers, but in a great many cases, they act in a quasi-judicial capacity with the acquiescence of parties concerned. I have to agree with all that. All kinds of buts and ifs and maybes involved, but that's really hasn't changed much in the last 150 years. there is a legal basis for surveying in Texas. At least 3 different laws that impact how surveys are done and what they're done. The past Texas legislature combined the Surveying and Engineering Practices Act. One of them can be cited as the Texas Engineering Practices Act, and it's direct quote out of the act. And the other short title is Professional Land Surveying Practices Act. Surveying is actually mentioned in both of these sections. Believe it or not, there is a engineering surveying component to registered professional engineering. The law says engineering survey includes any survey activity required to support bound conception, planning, design, construction, maintenance, or operation of an engineered project. The term doesn't include land and boundary surveying. The Act goes on to say that engineering is defined right here, and then the other part about what is engineering. But it says this is the practice of engineering. In the other section, it defines professional surveying to being a practice of land boundary or property surveying or something that looks like that. The last phrase is a little open-ended, but basically, professional land surveying is work necessary to determine the location of a land boundary. Additional acts of the legislature include the Natural Resources Code, which deals with surveys and surveyors and surveying field notes. This act deals with surveys in the terms of surveying of public land or public school lands. This is handled by a category of land surveyors known as the licensed state land surveyors. You'll see it as LSLS. This is the act that defines that character or that characterization of surveying and all the features that are involved with it. Field notes is a term of art, if you will, of surveying. This is not the notes that you made in the field where you recorded a measurement or recorded an angle or made a sketch of what a building looks like. This term, field notes, is a formal document that the licensed state land surveyor submits to the general land office to describe the location and boundaries of public school lands. You'll find that when you deal with surveyors that you're often using the same word for multiple things. It reminds me of a story that's told of a surveyor that went in front of the judge and says, "Judge, I was hired to locate the corners of the property, and I went to the corners of the property, and then corners weren't there, so I set them corners, and them corners are still there yet." This statute also describes the Texas coordinate system. It's a major impact on all land surveying and engineering surveying in the state of Texas. Texas Land Practicing Act requires certain activities of the registered surveyor before he can legitimately apply his seal to a survey report. Before I get away from it, it also allows the surveyor to apply a seal to a number of things, almost treat it like a notary public type seal. Not exactly, but it does permit the use of surveyor seal for making reports that may not involve locating a land boundary, but have an opinion or offer an opinion about other real estate issues. The Act requires the surveyor to abstract a piece of property. This term is intended in the traditional application of abstracting. An abstractor historically would begin with a piece of property when it's conveyed out of the sovereign, original survey, if you will. It will start there, and then it will evaluate every document associated with that piece of property. It will look at the boundaries of all properties that are inside there, and it will find all the easements. It also deals with divorces and deaths and other things. The abstracting that this act is talking about would require a surveyor to evaluate his property, conceivably back to the sovereign, determine what defines the boundaries of the property he is actually surveying. It requires the surveyor to honor junior and senior rights, which is part of the abstracting exercise. It requires the surveyor to honor dignity of cause. Dignity of cause that's being referred to here comes out of our friend Justice Smith's Stafford v. King, which we've already blown by. Dignity of cause, we'll remember, is that the things that define a property boundary begin with natural objects such as streams and mountains, semi-natural such as trees, artificial monuments such as iron rods, rocks, stakes set by a surveyor, and it does require that they were set by a surveyor. It's said that a small boy with a hatchet can blaze more trees in a day than a surveyor will blaze in a lifetime. Much the same with iron rods. Moving on, surveyors also work to standards promulgated by others. Bare minimum is those that are done by the Texas Land Surveying Practices Act, but typically contracts are made to perform surveys according to the Land Title Association standards that are promulgated, or Texas Society of Professional Land Surveyors standards that are promulgated. In Texas, the toss-up as to which one it gets used. If the lender or owner or title company is out of the state, most often off the surveys are required. Dr. Turpin, Professor of Civil Engineering, would begin surveying education courses with admonishment that one must identify and announce the purpose that a survey report or map is being prepared to support. Those announcements on the modern survey sometimes don't exist. It may become obvious that the content or or lack of content indicates what the purpose of the survey is. As an engineer, if you look at the drawing and you don't see any contours, you don't see any elevations, you don't see any engineering references, you can pretty well bet that the purpose of that survey was not intended for your use in the design. You can pretty well bet that it wasn't an engineering survey as defined by state law. Often, the only indication of purpose of the survey is this statement. Many surveyors have it imprinted in the printed form that they use to draw their surveys on. Today, the printed form is given way to a cell in a CAD file. It's in the border. Draftsman can't produce a drawing without that statement in there because it's in there. There's reasons for this statement. One, the surveyor is trying to cover his liabilities and minimize them, but also he's aware and it puts you on notice that there are things missing from the drawing or the survey report that would be necessary for a safe and confident construction project or engineering design. A more complete statement may be the survey is in support of this transaction only. Now, I've seen that put on a drawing that has no indication of what the transaction is, but even though that's a little sloppy, a more precise statement of exactly the same thing, the survey is in support of transaction anticipated by title commitment 123495684 issued by American Land Title Company or some such organization. Well, what does the surveyor seal mean on the drawing? According to the rules of Texas Board of Engineering and Land Surveying, it means it satisfies all the requirements of the board. And those rules are written out specifically in that deal. Kind of a curiosity, the board rules go on to say that if a surveyor certifies to something beyond what's required by certifying to an ALTA or a PSPS survey or to some engineering standard or whatever he comes across he needs to certify to, the board may use those standards to judge whether the work was done appropriately or not. Most surveys will have some type of certification on the face of them. Says we did such and such according to some standard. Both the ALTA and PSPS standards specify the wording of that certification. PSPS standards provide some flexibility in what it says. The ALTA instructions are very specific. If you change a word, a dot, a diddle, it's no longer an ALTA survey. Irregardless of that instruction, when I do one, I insert the word substantially complete or substantially in compliance with in the certification. Surveyors as a whole have been beat around the head and shoulders with instructions of do not certify to an absolute. what the certification is, saying you absolutely did everything exactly the way the instructions are laid out. So a little more onerous, and I'm willing to certify it too. Unless the attorneys get with me and we have a long conversation. Every survey will have, as I mentioned, something that says I certify two. This is an attempt to limit who is going to rely on this professional product. If your name's not there, you can rely on it the best you feel capable, but you have no recourse against the surveyor that had not listed you. You may get your client convey his rights and interest in the survey to you as the engineer. That may be fun. Most often, the survey didn't have what you really needed anyway. If the surveyor made a statement such as, survey property is not in a floodplain, you got a pretty good idea that he doesn't know what he's talking about. Every big property is in some type of floodplain, even if it's on top of a hill. You would really want to have a statement more along the lines of it's not shown on the FEMA firm. Abstracting, we talked about this some already. Surveyors typically will often put this statement on their survey. Surveyor did not abstract this property. You know right away that there's something amiss. One, that seal on the survey doesn't represent standards promulgated by the Texas Board of Professional Land Surveying. You also know that this surveyor doesn't truly know where the legal boundaries are of all of the property. I know that's outrageous to say. Often a surveyor will say he relied on the title commitment for all things in the record. This is great. At least you know that he's received a large amount of information about the property that the title company is issuing a warranty on. But I can tell you right now, title companies do not abstract. They do not look at adjoining properties to see if the adjoining property description overlaps with the property being surveyed. The only way that can be determined is if the surveyor does his own abstracting, finds the adjoining property description, traces it back to where that boundary line was gated, and determine the junior and senior rights for that piece of property. Every once in a while you'll run across the word access on a survey. Maybe a note that says property has access to Main Street. Access is actually a term of art of the legal profession. It involves much more than boundary location. It requires much more information than proximity of property lines to right-of-way lines. Access involves legal rights that can only be evaluated by an attorney. I typically won't certify to access. I will tell folks that their boundary line is coincident with the right-of-way line. I will even observe that I've seen vehicles crossing the property line into and out of property. If they want to know about access, I refer to their attorney based on the locative information provided by Surveyor. In the mix and match descriptions, you'll see the term more or less. Believe it or not, that is actually a statement of certainty. It is not a statement of uncertainty. The philosophy is, under the, I'll get to that next part in just a second. The philosophy is that if a boundary line is marked by physical objects, those objects are the boundary line. They mark it, they're identifiable in their own right, and the bearings and distances cited in the description are only descriptive or semi-locative. They will guide you to the location of the monument, and then the monument takes over. As you move down through the description, you'll see more or less used in several places. Sometimes it's used inside the bearing and distance to the monument. That is a somewhat redundant statement that the monument is the owner and not the bearing and distance. It is most often used when the acreage of the property is stated. If you're uncertain about the bearing and distances, you cannot be certain about the acreage. Therefore, statement more or less means there is some certainty to the boundary location because it's marked physically. There is some uncertainty about the acreage. Under this principle, the title companies will warranty property location if the monuments are set or called to be set, but they will not guarantee the acreage under any circumstance. Oh, and there is a slight extra charge. U.S. survey foot. And by the way, if you hadn't got the idea, we're just bouncing down through some terminology that we'll see on survey. U.S. survey foot. That's a little different from the empirical or imperial foot. Imperial foot being 0.3048 meters exactly. U.S. survey foot is a little bit different. This difference makes almost no importance for any particular measurement. It does come into play when you start applying difference to Texas Plain Coordinate System. In Texas, in Harris County, for example, the east-west coordinate value is in the 13 million range, plus 13 million. That difference of 0.061 comes into play and produces an impact of about 7 feet. The reason this may be of some interest to you is, as of this year, 2020, sometime later this year, I'm not sure when, the U.S. Coast and Geodetic Survey will discontinue using U.S. survey feet in publishing of coordinates. They will use the imperial foot. That's going to make a certain amount of uncertainty going forward to every set of state plain coordinates you look at for the valid plus or minus 7 feet. That's going to go into GPS calculations and observations, where you might think of GPS as being accurate to the size or diameter of a dime. Then you're going to have an uncertainty of 7 feet. That means you need to be absolutely certain of what vintage or coordinates you're working with. Already there's 3 or 4 of them out there that have you confused anyway. Keep your heads up. You'll see a statement that on survey the coordinates are Texas plain coordinates. If that doesn't tell you whether it's 1929, NAD 1929, or NAD 1983, or now NAD 2020, you don't have that supporting information. The coordinates are of little value other than very, very local value. You'll see on descriptions or on survey plats that coordinates are state plane coordinates, but distances are surface value. This is real information that has a measurable impact. And the Lambert conformal projection in Texas is the way it's been applied. Accuracies, inaccuracies can be as great as 1 part in 7,500. It makes you stop and think when you see survey standard requirements promulgated by TSPS or even the Texas Board of Professional Land Surveying calling for accuracies of 1 part in 10,000 or 1 part in 20,000. You have to be very, very careful how you handle state plane coordinates and their projections. It is doable, but it can be a large amount. This impact can be seen in the distances as short as 100 feet. And when you start calculating area, as small as 1/10 of an acre. This brings us back to Socrates. Are you still certain you know enough mathematics and surveying to know if you're being taken advantage of when you buy a piece of land? I think we're now ready for questions, if you have any. Pitch play, ignorance is not a seal of preparation, nor is it a hallmark of success.
Well, thank you very much, Andrew. And are there any questions? If you have some, please put them on the question and answer page.
I know very well that I have not presented this material thoroughly enough that I've cleared up all uncertainty in your mind.
All right. Well, I'm not seeing any questions come up.
Well, it looks like they're so flabbergasted that they can't even catch their breath.
Well, thank you. It's interesting how you tied it back to some of the early people that dealt with things we're doing today. So I sure want to thank you, and thank all of those who participated in the webinar today as listeners. And you still have time to enter a question while I'm talking if you do. And I'd like to thank you very much again, Andrew, for your presentation. And as Mike had mentioned at the beginning, individual registrants will receive an attendance acknowledgement, and you don't have to do anything further to get that. And again, but for those attending as a group, your site coordinator will receive the attendance acknowledgement for distribution to those sitting in the group. And if you're interested in presenting a Texas Section webinar, you can contact Mike at the email address given at the beginning of the presentation, and ASCE.org. And we do encourage you, if you have a topic you'd like to present on, to submit your expression of interest. You can visit the webinar page on the ASCE Texas Section website for a list of upcoming sessions. And our next one that is leading causes of litigation over the past decade, which will be on March 10th. As always, we're available to answer any questions and how you might be involved in the Texas section of ASCE. And now I'd like to turn it we have one question. Andrew, we have a question. Can you comment more on the impact of U.S. foot versus imperial?
Yes. I'm not completely certain of why the Department of Commerce, National Ocean Survey, National Geodetic Survey has decided to go this route, but because the imperial foot and the U.S. survey foot are in fact different units of measurement, the impact will be real. It only impacts the coordinate value for a given spot on the face of the earth. That's the real practical difference. And the reason that is important is because we are now beginning to work in a coordinate environment. What I mean by that is much of our work is being done with the GPS environment, or we're using coordinates in electronic total stations to lay out points on the ground. The big issue is the practitioner, the engineer, the surveyor, anybody else who is trying to identify a specific point on the ground needs to know what are the units in the coordinate system that's being referred to. You need to know absolutely what vintage, if you will, of coordinates they're being involved with. Every once in a while, there's a major change in the GOA that is being published. I like to say that it has more to do with canon accuracy than it has to do with surveying accuracy. But as GOAs are revised, the mathematics involved with that, mathematics involved with the geometry of the earth change, the mathematical projections of the surface of the earth to a mathematical surface such as a Lambert cone will change. All that is to say It ain't a problem if you know what the coordinate system is. It is a problem if you're guessing. I personally have stated coordinates for points that have the wrong coordinates in them, about 300 and something feet. If you're ever following my work down at State Highway 288 and FM 1462, call me or be careful. Work that I did based on the City of Houston monumentation that was done in the 70s, not by the way, I did some in the 80s, but the coordinates associated with that work are several feet different from the coordinates that you would find today using GPS equipment. And then there's the formal change from the 1929 National Horizontal Datum, National in 1983, and this change is coming up. It's going to be a double whammy. Just need to know what vintage of coordinates you're working with.
All right. Well, thank you very much for answering the question, and appreciate the question being asked. And seeing no further questions, I'll call back to Mike to close out.
All right. Thanks, everybody. Thank you for attending our session today. Please